Las Vegas's legal community is still talking about an LA Times series that took a critical look at local courts. The three-part effort, which took a year of investigation, was called Juice versus Justice. Its conclusion was that campaign contributions and connections create an uneven playing field before Las Vegas judges. With his perspective tonight, I'm joined by attorney, former municipal judge, and KNPR commentator Dayvid Figler. Good evening. Thank you for coming on our program. We appreciate it.
Thank you.
You say the series won't really change much. Why?
I don't think so. No real surprises to the legal community here. Everyone knows that judges need money to run their big campaigns. Billboards aren't free. Right. The signs that show up in everybody's yard or in the mailers, whatever. And judges ask freely, openly, all attorneys, please give me money. These are the same attorneys who appear in front of them. Some choose to, some choose not to, and life goes on. So the specifics were pretty interesting. The statistics were pretty interesting. It does cast a new light on the whole process, but the process is one that everyone's kind of gotten used to, so I'm not sure if it's going to cause any rapid reform. I think that it gives people something to think about, and I think the judiciary should welcome the open light, but I don't think it's going to change much.
I mean, the crux of the title of the series was Juice versus Justice. Are we getting more juice here than we're getting justice, essentially?
Well, see, that's the part of the article left unexplored. There was the appearance of impropriety. There was certainly the idea that there should be more disclosure of who has been giving you money, who are you friends with, etc. But we always have had a small and tight legal community in Las Vegas. They did not look at whether or not the rulings were proper or not. They didn't go to the next level because what judges do is they operate mostly in a zone of discretion. They can go in a lot of different ways without running afoul of the law. Now, if they were accusing some judges of actually making decisions that were contrary to the law to favor their friends, that's one thing. And I don't think the LA Times article went that deeply. It would have been interesting to see the particular decisions if other legal scholars, people looking in from the outside, said, oh, that was a completely wrong ruling. That ruling can't hold but for something else going on, and that something else may very well be a contribution. But that's not what they did.
It was very critical of the fact that judges here have to openly solicit campaign contributions from lawyers who come before them, from casinos, also parties that come before them. So with that aside, I mean, that's the system that we have here. What for your money, Mr. Figler, would be meaningful reform here? I mean, how do we change this system?
I think disclosure is huge.
Actually, let me backtrack.
Yeah.
Do we need to change the system?
It's a good question. I think that the scrutiny on judicial opinions, the way that the courtrooms run, needs to be in place. No one has taken the time really to do that. Now and again, a judge does something that causes the public eye to come in or the media to come in, and that's healthy. I think it's healthy for the system, but nothing systemic like what the LA Times here has done. Does there need to be some type of reform per se? Hard to say. Does there need to be more disclosure, more effort to eliminate this appearance of impropriety? Absolutely. So the campaign lists, those are things that need to be made maybe even more public. Although I think most judges would argue that if you really wanted to know who's given them money, they disclose all that on their election campaign reports. And if you're an attorney that's in there, especially in the civil realm, and this whole series focused on civil law, really, not on criminal law at all, which is a whole different thing, you could have a lot of different remedies. You could look that up yourself. You could actually pay a fee to get that judge eliminated from your case if you want. That's allowed in the law. And if you feel that the judge has done something that's afoul of the law, you can certainly appeal, as Judge Rose said.
You were a former judge. How did you handle the whole issue?
Well, it was easy for me because I'm just so juiced in that I got appointed. And I don't know if you know, but I am one of the most powerful men in all of Las Vegas. But my short tenure on the municipal court bench, I did not have to solicit any type of contributions, and I cheekily said that I would never do that. If ever faced with an election, I don't know if I would have to succumb to the pressure of doing that, or I could come up with some alternative way to actually mount a reasonable campaign.
Does this state want to change the system? I ask it only because we've tried it before. We've tried changing the system in terms of making them appointed, for example. That went down to defeat twice, I think in '72 and in '88, it went down to defeat. I mean, how much does this really resonate with the person out in the street, do you think?
Well, that's the thing, is that a lot of the cases that were discussed were people involved in multi-million-dollar or even $100,000 of litigation. The average person who has contact with the criminal justice system isn't at that level, and they're probably not feeling that they're being in any way mistreated in the criminal justice system. Again, the criminal realm is a whole different thing than we're talking about. So I don't think there's going to be a public outcry so much, but I think that if there's this much scrutiny being placed on our normal system, which everyone has agreed is legal, but perhaps looking a little more shaky than ever before, there is this talk of the appointed system. But of course, every system comes with its
pluses and minuses,
pros and cons. And you know, with the purely appointed system, you're going to have a greatly politicized judiciary, and some say that that's not such a bad thing.
You told the LA Times' Richard Abowitz that one of the untold parts of the story was the type of squeeze that a lot of judges put on lawyers to cough up some of the contributions. Talk to me about this squeeze that's going on out there. I mean, how does this work?
It's phone calls, it's letters, it's personalized letters. You've been a friend in the past. You know, you appreciate the justice that you do see here, and not facetiously, but that they're good judges, and they're reminding you, hey, remember me, I'm a good judge. Don't you want to see me continue to be a good judge, as opposed to someone else coming in here who you don't know? Mm-hmm. And you know, if you don't show up at the particular events or whatever, there's this sort of unspoken thing. I've never personally been subject of any individual judge saying, you know, where's my money, man? You know, mm-hmm. you want a good ruling, where's my money? I don't think it ever goes to that extent. But I have heard lots of stories about judges making personal calls, calling up, asking for the attorney, saying, hi, can I come over now and pick up that contribution? And then they list that contribution, and that contribution becomes a matter of public record. So wherein lies the impropriety is a matter of opinion. But the squeeze is something that a lot of attorneys feel very relieved that at least someone else is looking at it, that perhaps the system can change a little with regard to that type of pressure, because these are attorneys who appear in front of these judges, and it's really hard to say, you know, friend, I really don't want to give you money. Or worse, they give money to an opponent, and then they have to show up in front of that judge wondering if that judge knows or not.
Right. The discussion will continue, Mr. Figler. Appreciate
Absolutely.
your time. Thank you for
you.
joining us.